I'd like to start by acknowledging the traditional custodians of the land on which we meet, the Gadigal people of the Eora Nation. I pay my respects to their elders past and present, and extend that respect to other Indigenous people here. Welcome to the launch of the UNSW Law Journal, issue 39.1, which is the first of 4 issues due for publication this year. Each issue has a general and a thematic component. Tonight's issue has a thematic component on the law of elections and politics. I'm Wei An Tan, and I'm the 2016 Executive Editor of the journal. I'm very pleased to welcome you all here this evening. In particular, I'd like to extend a very warm welcome to Antony Green, to Ross Drinnen and the partners and solicitors of Allens, to Professor David Dixon, the Dean of the UNSW Faculty of Law, and our incoming Dean, Professor George Williams, as well as the editorial board of the journal and its alumni. I would also like to welcome Associate Professor Lydia Zinus, who was a contributing author to this issue. You'll hear plenty about tonight's issue from our other speakers, and so I won't say very much about it. My job instead is to acknowledge the work and the commitment and support of others, without which the journal could not accomplish its work. On behalf of the editorial board, I'd first like to thank Allens, our premier sponsor and host for tonight. Allens is our oldest sponsor, starting all the way back in 1981 in Volume 4, Issue 1. The journal is honoured and privileged to have such a long-standing relationship with Allens. I thank Ross Drinnen for welcoming us here this evening, and Lisa Miller and Liesl Gauman for their tireless work in organising and coordinating this event. I would also like to thank our 2 other premier sponsors, Herbert Smith Freehills and King & Wood Mallisons, for their continued support of the journal. Next, I'd like to thank the journal's student editorial board, who have volunteered their time and painstakingly edited every article in this issue multiple times. 2 months ago, we welcomed 16 new recruits to the board, and we're now at full capacity of 35. And our new recruits have settled in remarkably well, and we're grateful to have them here. As a student-run journal, we are very fortunate to have the timely and wise counsel of our 2 faculty advisors, Associate Professors Leroy Bennett-Moses and Michael Handler. We thank them for their guidance and their encouragement over the past year. Tonight's issue is the last that will be published while Professor David Dixon is the Dean of UNSW Law. For the last decade, the journal has been privileged to have David's unwavering support. All the former executive editors I've spoken to have highlighted David's commitment to the independence of the journal, which also demonstrates his faith in us as students to build on the great work of past editors. There really are so many ways one can thank a sponsor, and David must have done them all by now. But at the end of every launch, he gives such sincere and generous speeches, and he's been doing this for 10 years. David's door is always open for the journal, and we are grateful for his advice whenever sought, and his support whenever disputes arise, as they unfortunately do. On behalf of the journal, I'd like to thank David for his time and generosity, and to congratulate him for his great leadership of UNSW Law. Finally, I would like to acknowledge Damien Morris, the editor of tonight's issue. Since last April, Damien has worked around the clock to turn his idea of an issue about electoral law and politics into a reality. He prepared a call for submissions and tapped into electoral law networks that I didn't know existed. Then, over many months, he coordinated peer review, editing, and printing. Of course, it wasn't enough for Damien to be on top of his own work. In his spare time, Damien managed to find the energy to redraft our Constitution, develop an extensive list of suggestions for the next iteration of the Australian Guide to Legal Citation, and improve our internal practices to improve our communication with authors, which, if I may say so, has been quite a hit. When I was a new executive editor, Damien answered many, many silly questions from me at odd hours of the night, and I just want to thank Damien for his patience, his leadership, and good humour. The last thing I'll say is that Damien's phone manner is absolutely impeccable, and the regular callers to our office will no doubt be disappointed that he no longer works here. Congratulations, Damien, on your remarkable achievement. On that note, I'd like to introduce Ross Drinnen to speak on behalf of Allens. Ross is a partner at the firm and is the practice leader of commercial litigation and dispute resolution. He has over 20 years' experience in commercial litigation, including in some of Australia's biggest class actions, regulatory investigations, and banking disputes. We're grateful for his time. Thank you, Ross.
I'd prefer to think of us as your most loyal sponsor rather than your oldest sponsor, Anne, but we are very proud of our long association with this journal. It is a very significant contribution to academic discourse in this country, and I think what is particularly remarkable is the quality of the publication, it being an entirely student-led law journal, which makes it quite an unusual beast on the landscape, and it's a proud tradition, and long may it continue. It means that every year, when it comes time to decide where to invest scarce dollars for sponsorship of a whole range of worthy pursuits that we can turn our attention to, it makes it very easy to mount the argument why we should continue this association. So congratulations, we're delighted to host this evening's launch. Particular welcome to speaker Antony Green. We look forward to hearing what you have to say. I think this is a perfectly timed launch. I'm not sure who was inspired to work out that it should go first, and what appears to be only a matter of weeks before what's proving to be a very interesting time when it comes to the law of election and politics. So thank you for joining us, and congratulations to the editors who've been involved. And I will now hand over to Damien. Thank you.
Good evening and welcome to the launch of issue 39.1 of the University of New South Wales Law Journal. I have to say, when I was preparing for this speech, I tried to think what was the first thing that sort of came into my mind when I'd realised I'd completed 1 year at the helm of this issue. And the first thing that popped into my mind was how curious of a thing editing actually is. No matter how much you strive for perfection and consistency, the harder you try, the more errors slip through your fingers, as I'm sure most of our editors here know. And in fact, before the launch, in order to pep me up, Anne told me this anecdote from previous launches. Apparently, there used to be an alumnus of the UNSW Law Journal who attended these events, and when he got here, he'd take a copy of the journal, he'd have a look through, and he'd start finding all the errors that remained in the issue. And then he'd find the issue editor, and he'd show them what the errors were. And I thought to myself, this is Anne's idea of a pep-up speech. But I also thought of something else. And I thought that what really matters when it comes to publishing things such as this, when it comes to publishing academic works, what really matters is not so much that you've managed to completely identify every rule of the ADLC or dot absolutely every single T or you wouldn't dot the T's, but cross every single T and dot every single I. What matters is that what you have published is correct. The footnotes are accurate. The information you provided enables the reader to identify what the argument is. And I can say with confidence that due to the work of all the editors of the UNSW Law Journal over the past couple of months who have put in the hours to checking those sources and checking those footnotes for this issue, that is the case. They have done an excellent job, and I'm confident that that all those footnotes and citations are correct. And to someone who isn't an editor, that may sound an odd thing to say, but once you've worked on an issue for over a year, it's actually a very, very special thing, and it's something I'm very, very proud of to say that I believe that I and the editors who've worked on this issue have done the best they can to make sure that it is a really good quality piece of scholarship. And I would also like to point out that in relation to that anecdote that Anne told me, it is rather ironic that one of the worst fears of someone who, for a living, looks and identifies errors and corrects errors in someone else's work, the worst fear of theirs is also being caught out and having errors identified in their work. And that just tickled my fancy when he told me that. But yes, Wian has very much has done a very good job of thanking the people who worked to make sure that this issue becomes a reality every year. Our sponsors, in particular, our sponsor for this event, Allens, and our other premier sponsors, our faculty advisors, Associate Professors Michael Handler and Lyria Bennett-Moses, and of course the Dean, Professor David Dixon. And I cannot top what he has already said about those people. But if I could, I would like to add a couple more comments on two other categories of people who I'd like to specially thank. The first, as you may have guessed, are the editors from the editorial board, who have put in many, many hard hours over the past couple of months to try and make this issue a reality. And in particular, all those who worked over the summer and who did double edits because we didn't have enough people, who put in all those extra hours to try and make sure it was a quality product. It's something that I'm very, very thankful for and very, very grateful to all people who did that. I'd also like to thank my fellow members of the Executive Committee of the Journal, who, again, have put in a lot of work, but perhaps more at the advice and the counselling side of things, who have always been there for support, who have always been there in order to lend a helping hand when something just got too much to handle, and when I needed someone else to help me out. And their assistance has been of inestimable value. The second category of person who I would like to thank is my family, my mum and dad, and my brothers, and as well my partner Daniel Latchford, who have had to put up with the many, many long hours that I've put into making this issue and editing it and making sure everything's correct. Your patience has been absolutely wonderful, and I'm very, very thankful that you've been able to put up with me for many, many long nights spent at university, many, many long nights not turning up for dinner at home. So thank you very much for that. But turning to more interesting matters, perhaps, for the majority of people in this room, talking about the issue at hand. As many of you will know, there are two parts to the issue. There's a general component and a thematic component. Both of whom are equally part of the journal's repertoire. The general articles in this issue range over a variety of topics, starting from the legislative history of euthanasia by Professors Wilmot and her colleagues up at the Queensland University of Technology and the Health Law Centre there, to articles such as that by Associate Professor Gabrielle Appleby and Dr. Adam Webster on cycling and the law. Again, another very, very topical issue for many of us in this room, anyone basically who drives or uses the roads. Cycling and the law is a very, very important area where we've seen a lot of development recently, and it's very, very interesting that such a niche area has managed to find its way. Well, I shouldn't say interesting. I think it's great that such a niche area has managed to find its way into the issue. But turning now to the thematic, Ross pointed it out. He said that that the timing of this issue was very, very good, and I have to say it's not a coincidence that we have a double dissolution election coming up very, very shortly. It was planned. In fact, back in April, Justin, our digital editor who handles our marketing, we were having a discussion and we were thinking, okay, how can we promote this issue? How can we get people to turn up? And at the time, if you remember, there was a lot of debate about Senate voting reform, which I find personally very interesting, perhaps not for so many of the other students at the UNSW Faculty of Law. So I thought, okay, what have we got to do to get people here? And so I was thinking, and that night I made a phone call. And I said, Malcolm, look, we've got this issue on law of elections and politics coming out, end of April. Is there anything you could do for us? And he said, oh, I'll see what I can do. Then I wake up the next morning and Parliament's been prorogued and there's another special sitting and a double dissolution elections looking like it's going to become a reality. So there was a lot of planning that went into that, so it's not just chance. But more fundamentally, those issues about Senate voting reform and about how our parliamentary system operates, I believe express fundamental values about fundamental values that we hold in Australia, fundamental values that underpin our democracy and about how we regulate our society. And so when I put out the call, I was interested in how all these rules, which people regard as very, very technical, about Senate voting rules, about formality, about savings provisions, I was interested in how those rules actually express those fundamental values which we have in our democracy. And I think what a lot of people are realising after all this debate about Senate voting reform, or hopefully realising, is that all these technical rules actually do matter when it comes to the type of democracy that we want to have. Whether the parties control who has the flow of preferences on your ballot paper, or whether it's up to you. That is something which is so fundamental to how our democracy operates, and it's something that for the first time is really being brought into the limelight. And that type of issue is something that I hoped to bring to the fore in this thematic component, and that's something that I think we've achieved. And if I quickly look through the types of articles that we're publishing, we've got an article on regulating opinion polling, another very, very topical issue in Australia, with all the debate around how closely politicians should look at opinion polls. We've got an article that looks at informed voting, both at constitutional referendums and when making, just at constitutional referendums. As well, we've got an article which looks at who is allowed to vote. We've got an article which looks at how the role of the people and the electors under the Constitution, how that defines the High Court's jurisprudence when it looks at these electoral matters. All of these things focus on technical rules that constitute our nation today, and all of those things express fundamental values about the way we order our society. And today, we're very, very lucky to have Mr. Antony Green, the ABC's leading election commentator and psephologist, and that's a word which I hope to use much, much more often now that I know it. Leading election commentator and psephologist to discuss some of these issues. And Antony has a reputation as someone who's very, very good with numbers, and indeed his original degree at university involved pure mathematics and computer science. However, much of the work that Antony does also comments upon exactly what I've been describing, those normative issues which lie at the heart of all these very, very technical rules. That's why I invited him to give the keynote address at this launch today, and that's why I'm very, very happy to introduce Mr. Antony Green to speak to us now.
It's a pleasure to be here. My first degree was a science degree in pure maths and computing, straight after school. I was the archetypal migrant kid from the north of England. Parents came out here, got a better education and opportunity than I ever would have in my hometown, and did well out of it, but sort of opted for the technical profession, and then for a variety of reasons ended up going back to university in the mid-80s and studying a Bachelor of Economics, majoring in government, and that was a great time to study economics and politics during the early years of the Hawke government. At the end of that, I was hunting around for a job, trying to figure out what to do, and I was back writing computer code because I was quite good at that and it paid well. And I saw a job in the Australian for a 6-month contract for researcher at the ABC to work on the 1990 federal election. Had to have knowledge of electoral systems and elections, knowledge of computers, background in media, something else. I had everything else except the media. But I applied. I thought, great fun. I can do that. And I was, at the time, looking for a job as a trainee economist, and I thought I could always go back to economics. So 150 people applied for the job, and they interviewed 8, 3 with PhDs, and they picked me. And I think one of the main reasons was my bubbling, sparkling enthusiasm. But secondly, the computer background, which at the time was quite rare, and I think they thought I could talk to the computer people. So I worked on that and did a book of notes, and at the end of election night in 1990, which went to about 1:30 in the morning, Andrew Olley and Paul Lynham and Kerry O'Brien all told the head of News and Current Affairs, you should re-employ that bloke, he knows what he's doing. And so they did, and they gave me the job of redesigning their computer system to do election nights, which I did, and we still basically use the same system today. It does all those accurate predictions, which no one else has, so I designed all that. Still a great telling point. We were doing a discussion today for the planning of the election coverage, and we were talking about the bottom of frame where the numbers of seats won by each party is displayed, and one of the graphic artists was saying, it's a bit boring, it's the same numbers all the night, and I said, yeah, but they're miles ahead of anybody else, so we're quite happy to stick with them. But they also stuck me on camera one day and they decided it made sense, and it just went from there, so quite an unusual occupation. But as a result, I've got a mix of professions and skills, mathematical background, strong background in history, a smattering of constitutional law, especially in the area of conventions, which is where most politics tends to occur rather than the hard law. It's actually the conventions surrounding the law, which is often more important in politics, although Gough Whitlam didn't understand that in 1975. So, on to this publication, which has got some interesting papers. Now, I'm told none of the authors are here, so I don't have to apologise for mispronouncing any names because I haven't had a chance to check them. But I'm going to particularly talk in a while on the savings provisions aspects of the paper on savings provisions, which I find most interesting. But I'll touch briefly on some of the other papers. Alexander Riley and I think it's Tiziana Torresi on voting rights of permanent residents. Second section of the paper started with a paragraph, very few nations currently grant voting rights to non-citizens in national elections. So you knew they were in a tough case when they say that at the very beginning. But I must say, as a migrant kid who came as a 4-year-old, and when I started to vote in 1978, I was not a citizen and I had the right to vote. And after 1984, when they stopped non-citizens getting on the electoral roll, I continued to have that right because I had been on the roll in 84, and there are still Australians today who are not citizens who still have that right. So it is more interesting to have that argument on the basis of how citizenship has changed over the years. And there are many papers which aren't legal papers on that issue of the changing perceptions of citizenship in this country. And what you need to look at is things like changing flags, changing national anthems. I had to swear allegiance to the Queen, which people no longer have to do. So these things do change over time. And as George Williams and others will talk about, Hill versus Sue, or whatever the case was, where the High Court finally accepted that the British Crown and the Australian Crown were different, and one couldn't have allegiance to both at the same time. A very important case, but one that people don't really understand sometimes what emotionally that meant as well as constitutionally. I think Elisa Arcioni, the core of the Australian Constitution, the people and the electors, I thought that was wonderful for reminding me of a section of Section 128 of the Constitution which I'd forgotten about entirely, because it's one of those until the Parliament otherwise provides sections, so you tend to skip over it. And there it is in paragraph 4, about putting forward a constitution. And then it says, but until the qualifications of electors of members of the House of Representatives becomes uniform throughout the Commonwealth, only 1/2 of electors voting for and against the proposed law shall be counted in any state in which adult suffrage prevails. Now, I must have read that at some point in my life and then not really understood the relevance of it until this paper pointed out to me this was because women had the vote in South Australia, and everyone was very concerned that South Australian votes therefore carried twice the weight of the rest of the country. I don't think Edmund Barton's reputation would be as good if people knew his response, which is included in this paper, that perhaps the section should include a section only the votes of men should be counted. And he also, in the same section paper, makes some comments about the narrow interpretation of the word he in reference to elected members of Parliament. He was one of the only members of the convention who thought he meant male, which was interesting to see that. The paper was interesting for that point, for reminding me that these issues in relation to women voting in 1901 was very relevant in terms of what's the definition of the people. And some others have done very detailed papers on how many Indigenous Australians in some states lost the right to vote in 1902 because of the changes laws. And in fact, that section wasn't used to protect their rights. The relevant section, I think it's 41, wasn't used to protect their rights at the time. Graham Moore and Ron Levy do a paper on regulating opinion polls, to which my thought was, are they trying to actually stop newspapers having the only exclusive they still have? It is interesting, having worked on Australian elections, we have no rules on when results can be reported in this country. In Canada, for a number of years, for a decade, they tried to hold back the world, and they stopped any results from the eastern states being reported until polling closed in British Columbia. In the age of the internet and Facebook and Twitter, this was becoming increasingly untenable, and the recent Canadian election finally abolished that ban. The American networks do not have a similar ban, but the networks themselves have their own rules on that, on reporting results on election night. Because all elections in America are held on the same day, calling the American election too early in the eastern states has a significant impact on turnout on all other elections in California. If people think the president's already been determined, they may not turn out to vote. And that has an impact on the California Congress, the Californian governor, the referendums, local government, the dog catchers, the mayor, all those other elections which are held on the same day. So the convention is they do not call the elections too early. And of course, the famous case of 2000, when they called the election too early and they were wrong, has proved that case ever since. So in 2012, when I was asked to do election coverage for the ABC, for the American election. I'd had the odd experience of being in New Zealand watching Barack Obama claim victory. Don't ask me why. I think it was a New Zealand election. Straight after Obama's speech, I had to go give commentary on a debate between Helen Clark and John Key. And I think my first comment was, I thought the rhetoric of the debate was less overpowering than what we heard earlier, and it certainly was. But anyway, no one would call Obama won when he'd won Ohio and Pennsylvania, which was clear, but nobody would call it. So when I was asked to do a coverage here, I remember sitting down with the head of news and sort of saying, well, I'll do it if we can give away the decided states on the polls. Can you do that? I said, yeah. We're in Australia. Nobody's watching from America. We can do what we like. So we called all the safe states early. So we gave California to Obama in 2012 at the start of the coverage. What was the point of hanging around for 3 hours when we knew who'd won? So right at the start, we gave away the states. And so for 3 hours, we had seat numbers at the bottom of the ABC screen, which were miles ahead of the American networks. Much more. We weren't doing anything new. When they gave away a state in the close states, we gave it away about 30 seconds later, because we just did it. And so we didn't call it before anybody else. And in fact, because Ohio was the key state, you couldn't call it till Ohio came in. We just did it. But I mean, it was an interesting experiment to look at how people think you can or can't do something. In Australia, we have no rules, and never have. We've always broadcast results into Western Australia ahead of time. Some people many years ago thought that was odd. But again, in the age of Facebook and Twitter, how would you ever stop that occurring? You could take the Canadian example of stagger the hours, but it's too difficult to do. Paul Kildea and Rodney Smith, has done a paper on the challenges of informed voting at constitutional referendums. To me, that is quite fascinating because Queensland just had a referendum on fixed 4-year terms. And nobody thought it had a hope of getting up. Who was going to vote the Queensland Parliament to have another 4 years and fixed? Have 4 years and fixed, given the government had nearly fallen over the week before when someone left the government, given that people hated Campbell Newman when he left office, they hated Anna Bligh when she left office. Why would they go and vote for fixed 4-year terms? Anyway, the government put up 2 cases, a yes case and a no case. Neither of them are particularly exciting. The yes case sort of said everybody who supported it. It's got broad support, the workers support it, business supports it, tourism, local government, seniors, and gives a couple of basic arguments. The no case set out the cases which were pretty obvious, Queenslanders will have to wait longer to vote out bad governments. It's the wrong for a state with no upper house. Increased social cost puts politicians' job security ahead of voters' rights. Who supports it? The ALP government, the LNP opposition, politicians. Why? So, I mean, it's just wonderful stuff. And then Professor Graham Orr was quoted as saying, "It is naive to think that just by changing to 4-year terms, you are going to improve the culture of executive government." The people voted 53% yes. It just astonished everybody. An incredibly low-key referendum, and the public voted yes. Does this mean perhaps that we shouldn't have informed debates? We should just hold the referendums and not tell anyone about it? It does raise that interesting question. Of course, referendums at the federal level have been more political in that sense. Not since 1977 have we had referendums with bipartisan support. This referendum had bipartisan support. A similar referendum in New South Wales in 1995 on fixed 4-year terms also passed with bipartisan support. But, having said all those things, and that quote from Graham Orr and the problems of the upper house, what should happen 2 weeks later? But the government had a bill put forward by the opposition to add 4 seats to the House of to the Legislative Assembly. A reasonable measure. The government didn't like it because the seats probably wouldn't be in areas where the Labor Party would do well. They would go in growth areas where the LNP does well. So they were opposed to it. But the crossbench, the government not having a majority, backed it. And so the government, the opposition, with the help of the crossbenchers and some defecting Labor members, now independents on the crossbench, thought they would move this bill and give it urgency, which they did, and they moved it. And it got through the first reading and the second reading and into the committee stage, at which point, snap, the government moved an amendment to abolish optional preferential voting. Fundamental change to the way people fill in their ballot papers, the way the ballot papers are counted. 18 minutes notice, they moved this amendment. They'd already keyed it up with the crossbenchers. The bill's in committee. They've got the numbers. It goes through the committee to the third reading. The opposition has no choice at this stage, having lined up the crossbenchers, but to back the bill that came out of committee. So with no warning, no prior consultation, no discussion with anybody, A principle that had been in place in Queensland since 1992 as a follow-on from the Fitzgerald Commission was just abolished between 4 o'clock and 7 o'clock in the afternoon with no warning. Truly an astonishing thing to do, and something that could only happen in Queensland was what everybody warned about 3 weeks earlier with the referendum. So I thought it was appalling, and I've had people coming onto my blog sort of saying, oh, it's all right for governments to do that. No, it's not. No, these are the same people who criticised Campbell Newman for all sorts of things. When he introduced changes to have ID laws, he actually put it out for submissions. I mean, they ignored the submissions and paid no attention to anybody, but they went through a process. I mean, this was not a process. This was like, right, guys, we're doing this, bang, whack, through. And that's what happened. So the next election, Queensland will have to number all the squares, which is where he comes to the final paper in this issue, which is by Narelle Marigliotta and Zim Nkwara, I think it's pronounced. They've done an issue on the issue of savings provisions. Savings provisions, and it's very relevant at the moment, coming up with Senate reform, are what you do with ballot papers to allow as many ballot papers to count as possible. We have very complex methods of counting in this country, of voting in this country. Most people in the world turn up, with the exception of the Americans, where they've got dozens and dozens of elections on the same day. They turn up and they one mark on a ballot paper, and that's all they do. It may be proportional representation, it may be first past the post, but the overwhelming majority of people in the world make one mark, usually a cross. That's all they have to do. In Australia, we make people turn up to vote for a start, and then we make them fill in all the squares, and then we present them with ballot papers like this. This, for those of you who aren't old enough, is the 1999 New South Wales Upper House ballot paper, the famous tablecloth. It has 264 candidates and 81 columns. Now, thankfully, if you look at the top here, it's above and below the line voting, but they triple-decked it. So if you can understand why there are these 3 lines with lots of names and stuff like that and all this down there. Now, to conduct this election, there were so many laws broken. They had to hire bigger aeroplanes to fly the ballot papers across the state. Heavier paper. What else did they do? The glue on the postal vote envelopes wasn't strong enough to hold them closed with this ballot paper folded up. So all these postal votes are arriving open, having flipped open. People putting in pre-poll votes, they had to widen the slots on all the boxes so you could get the paper in, which meant you could put your hand in and pull ballot papers out. I mean, it was like there was so many things wrong. And then when they counted them, it was all done at a centre in Pyrmont. Take a look at it. And in the middle of the count, New South Wales was hit by one of the worst hailstorms in our history. And all the above-the-line votes were all sealed up in plastic in this room at the back where the roof collapsed. An asbestos roof. So to access all those ballot papers for the continuing the count, they had to go in moon suits to go and pick through the remains of the asbestos ceiling. But anyway, they eventually won it, and it's a remarkable result. That was the first case of preference harvesting. Glenn Drury, who we all know as the preference whisperer nowadays, organised at least 20 of the parties on that ballot paper. And there were some great parties. There's the Marijuana Smokers' Rights Party, which is one of the ones he already got 2%. It did quite well. And then there was the Gay and Lesbian Party, which apparently had no gay and lesbian members. It was a bunch of four-wheel drive activists. And there was a bunch of gay rights activists who'd organised a party called Stop Banks Exploiting Australians. So there was all sorts of things going on with that system. So anyway, let's just pass over that as a mad little occurrence. So that's where lots of people got this idea about stuff. But this is also why you need savings provisions. And where's my lower house ballot papers gone? They're here somewhere. Just lost them. Doesn't matter. When you fill in a ballot, here we are. When you fill in a ballot paper in this country, you have to fill in all the squares. That's a lower house ballot paper. I think it's a Benelong in 1998. You must number all the squares 1 to 13. It's got I forgot about this. There's a gentleman on this ballot paper called Prime Minister John Pissed the Family Court and Legal Aid. There's a party called Abolish Child Support Family Court Party. They all changed their name by deed poll. One of them changed his name to John, the Family Court Won't Let Me See My Children. Anyway, they changed the law after to stop people having false names. And unfortunately, there was a Brisbane drag queen called Tamara Tonight who promptly found she couldn't run for Parliament anymore. But such are the joys of names. Anyway, you must number 1 to 13 on this ballot paper. And if you make an error, too bad. Your error it's wrong. And to solve that, there are two types of general provisions in the Electoral Act. One is a broad provision that a ballot paper should remain formal as long as the voter's intent is clear. That's not much use in a system like that, because the only ballot paper that gets saved by that is if the last square is blank, where it's presumed to be the last number, or where there is confusion over the numbers between 1 and 7. People who cross the number and use the European-style numbering. There's confusion over the numbering, and it's now been ruled that you must look at the whole entirety of the ballot paper, not just the two numbers, the whole sequence. So there's a number of very small provisions. What's more interesting is optional preferential voting as applies in New South Wales, where you only have to fill in one square and everything else is beyond that is optional. And the case I'll raise there is what happened in that sort of law. In 1980, we introduced optional preferential voting in New South Wales, and the Rand government entrenched in the Constitution. It can only be repealed by referendum, which is another interesting bit of constitutional law in this country that you can insert things in constitutions and then entrench them in various ways. But optional preferential voting is entrenched. An election or two later, there was a dispute at a close election on whether ticks and crosses should be allowed, and the court ruled that the voter's intent was clear. There are criminal cases in this country all year round, fraud cases, where the intent of a mark on a form has to be imputed by the court. What was the intent of the vote? What was the intent of the mark on this social security form? So there is lots of law on intent of marks on paper, and that has been translated into electoral law under optional preferential voting. If you use a single tick or a single cross and there's no other mark on the ballot paper, that can be imputed to be a 1. What happened in 1991, in a somewhat disgraceful situation, the Griner government decided to hold a referendum. It passed, and I'll just read this out because it's a great bit of referendum. Do you approve of it? Was going to cut the size of the Legislative Council and shorten the terms and elect half the council every 4 years instead of 1/3. Do you approve of a bill to reduce the number of politicians in the Legislative Council and to reduce their maximum term of office? Yes! To apply the Legislative Council the same rules for filling casual vacancies as the Senate. I mean, the wording of the question about reducing the number of politicians was why that referendum passed with 57% support, despite Labor opposition. But before that election, they changed the formality rules, these savings provisions, and they specifically excluded ticks and crosses at that election. So that if you used a tick or a cross on your ballot paper, it was informal. It had been formal for the previous 3 by this implication, but they deliberately ruled it out. That referendum was held the same day with a ballot paper which had 2 boxes, yes and no, and the instructions were to cross one of the boxes. But if you used that cross on the other ballot paper, it was informal. And in the 4 electorates where there were only 2 candidates, the informal rate shot up to 25% in one of them. The rate of informal voting at that election in New South Wales was tripled to 9.3%, as high as 25 and 30% in parts of Bankstown and Penrith, where people, given a ballot paper with 2 boxes saying use an X, and another ballot paper where it said use a 1, they used an X again, and it was informal because they'd changed the formality rules. That shows why these sorts of rules are important. We are imputing what the intent is, but that's all we have. An election is people have filled in a ballot paper. We know who they voted for. Can we imply from it? Optional preferential voting gives you lots of rules about how to do that. Which brings me on to the current Senate changes that are occurring. What happened with the Senate ballot paper, and I'll get that prop. This is the New South Wales ballot paper from the last federal election. It's not as big as that. It's only got 110 candidates. But under federal electoral law, they can't triple deck or double deck. They have to appear on a single line. So the only option was to make the print size smaller. And because the print size was made smaller, they issued magnifying glasses. So you could read that. So you could sit with your 1 metre ballot paper in your 600 millimetre polling state with your magnifying glass and your pencil and try and figure out to vote 1 above the line or 1 to 110 below. Understandably, 98% of people voted 1 above the line, including 9.5% who voted for David Leyonhjelm and the Liberal Democrats in column A, clearly not having understood that was not the Liberals and Nationals, who were about 2/3 away along the ballot paper. I think it is a thundering disgrace to conduct an election in these circumstances where people need a magnifying glass to vote on such a ridiculous ballot paper, which they can't read. You needed the dexterity of a contortionist to vote, the eyesight of a hawk, and the manual skills of an origami artist. So something had to be done, and the proposal has been to get rid of the ticket voting system. There will still be above and below the line voting. You only have to vote 1 to 6 above, and you can vote 1 to 12 below. But for me, the sticking point in all the discussions, which is the New South Wales system since 2003, the sticking point in this was, what do you do about people who've just voted 1? That was the original proposal from the Joint Standing Committee on Electoral Matters. It was broadened because there was concern there would be too many exhausted preferences, and the quota was 14.3%, unlike 4.5% in New South Wales. So they wanted people to fill in more squares, which is where this idea of 1 to 6, and when I first started to discuss this with the Greens and Nick Xenophon, I said, you have to have a savings provision. What's a savings provision? A savings provision is something that allows you to say this ballot paper has not been filled in according to the instructions, but we believe its intent is still clear enough and the motive of the person filling in the ballot paper is still strong enough that we will count that ballot paper. In this country, because of full preferential voting, we have a lot of rules explaining why you can't count a ballot paper and not enough explaining why you can. We had the Bradfield by-election in 2009, which had 22 candidates, including 9 Christian Democrats. The Liberal Party got 56% of the vote. There were 73,000 ballot papers, and all 73,000 were checked for a sequence of 1 to 22 being correctly filled in. Now, the Liberal candidate got 56%. Not one preference needed to be counted in that election, but they still checked all 73,000 ballot papers for sequence of 1 to 22, despite the fact none of those preferences were required. So in other words, we've got rules which define what can't count rather than what can count. My prime motive in the Senate reforms was to ensure that people's intents could still count. And for 30 years in this country, people had just voted 1 in the Senate. And oddly enough, people don't read legislation very often. They don't always read the instructions on their ballot papers. Talk to anybody who works in retail as to whether people read the instructions when they're taking a new television or computer or electrical appliance home. They don't. They think they know how it runs. They plugs it in, it blows up, and then they wonder what's wrong. It's the same with voting. They presume that most politicians aren't going to do something stupid which will deprive them of their vote. So a significant number, 15 to 20%, might turn up and just vote 1. So you've got to have a savings provision for that, and I kept hammering that, and everybody agreed, and that was what was in the final bill, that if the instructions say you must vote at least 1 to 6, if you only vote 1 or you vote 1, 2, or you make an error and go 1, 2, 2, it will still count because it's got a valid first preference, and those preferences will now only apply to that ticket. If you want the system has abolished any party control over preferences. It's now entirely under the control of any party control. It's now entirely under the control of the voters. Outside of a party ticket, the only preferences that count are the ones filled in by voters, and I consider that's an improvement that we'll find out next week in the High Court whether that stands up to challenge. And my view is it will stand up easily, and certainly if the ticket system in the new system is ruled invalid by the High Court, it's impossible to see how the existing ticket voting system could remain valid. So that was put up, and that will ensure there isn't a huge surge in informal vote. Anyone who's turned up and voted above the line of the current system will still have a formal vote under the new system. Because in fact, back in 1984 when the current system was introduced, the argument was over optional versus full preferential voting, because we had 9.5% informal vote from 1922 to 1983, and nobody seems to have quite agreed that it was caused by compulsory preferential voting and maybe you should do something about it. But it took 60 years before somebody tried to do something about it. Nobody would accept optional preferential voting, so they invented ticket voting. What's happening now is we're going back to the debate about optional versus full preferential voting. I then had the strange situation where the government had retained this idea of you must number all the squares below the line. And I sort of went through a whole bunch of logic about why this was a problem and why this would get the High Court sniffing around the edges. Because if you voted 1 to 6 above the line, and an individual group could have up to 2 candidates, then that corresponded to 12 candidates below the line. But if you voted for those same candidates 1 to 12 below the line, it was going to be informal. More importantly, if you wanted to put those 12 candidates in a different order than the tickets, it was going to be informal. You would have to number all the squares. And I said I didn't think there was a constitutional problem, but the High Court would be asking some very rude questions about what was this formality about. I had Matthias Coleman on the phone. can I talk to you? You're very important in this. And then we went backwards and forwards. And about the following Monday, I suddenly got this phone call with thinking of making it 1 to 12 below the line. Yes, I thought. And then he said, what do you think we should have as a savings provision? And savings provisions are funny things. And I looked at what was instructions, and I said, well, how about 1 to 6 below the line is okay, because if someone reads the ballot paper, it says vote 1 to 6 above, and if someone reads that and goes 1 to 6 below, it will be informal. So that's what was written into the Act. You must vote 1 to 6, even though it says 1 to 12. Again, there's also some conspiracies. People think this is all there so that people can do a Just Vote 1 campaign. No. The parties aren't interested in the Just Vote 1 campaign for the Senate. They're handing out how-to-vote cards for lower houses, and they don't want anyone thinking a Just Vote 1 is okay in the House, because that's informal. But then people start saying, well, we should be publicising the savings provisions. And my view is the intent of the Act is they want people to give preferences, and that's what they are saying on the ballot paper, and I think that's what should be encouraged, and I'll continue to argue that. But you don't write the savings provisions on the ballot paper. The current savings provision, if you vote below the line, is you only have to fill in 90% of the squares, and you must make no more than 3 sequencing errors. You couldn't put that on a ballot paper. Nobody understands what it means. In fact, most of the scrutineers don't know what it means. They use a computer program to check. But there are still some peculiarities in our system. If you vote 1, 2, 3, 99, or 100 on a ballot paper, it's informal because you've broken the sequence. I think it's pretty damn clear what the voter intended on that ballot paper, but it's informal. I'd love to see more of these rules checked, and these are sorts of things that can be written into the Act and the paper that Narelle and Zim put out. They point to some of these issues, but they're looking at it in a more generic way. I've pointed out a couple of scandals like the New South Wales 91 election, where these things have some relevance, which is why these laws are important. There was a letter in the, and I'll finish with this point, there was a letter in the Australian several weeks ago criticising the Electoral Commission for allowing the Senate ballot papers to get as unreadable and unwieldy as this, and for not ruling out parties which were clearly fronts. Well, in law, how do you define a front party? You try and write a law which defines a party as a front for somebody else. How do you do it? So, the Electoral Commission can't reject a party for being a front because there's no such thing in the Act anyway. And as for the shape of the ballot paper, well, that's in the Act. The Electoral Commission is not responsible for the Act. The politicians are responsible for the Act. So I keep getting interviews with outraged electoral radio people sort of saying, why doesn't the Electoral Commission do something about this? Well, it can't. I mean, we had great fun. Who's the WikiLeaks bloke? Julian Assange. I don't know anybody who can figure out how he could lodge an enrolment form at the last election. He's lived overseas for years. He's off the electoral roll. How does he get back on the electoral roll? Well, there's a simple reason. The Electoral Commission can't refuse it if he claims that he is. If he swears that he is entitled, it's not for the Electoral Commission to question it. So it takes it. If after the election he were elected, then you could take it to the High Court and rule that he wasn't on the electoral roll and therefore he shouldn't have been a candidate. And there were all sorts of funny constitutional cases that flowed from that. But outraged people saying, why did the Electoral Commission allow that? Well, simple, that's what the law says. And that's where some of these journal articles are very important, for pointing out some of the fairly obvious points, that elections rely on law, and there are things that electoral commissions can't do, and it's because the law doesn't allow them to. And if people want to make complaints about the law, the people they should be complaining to is politicians, not the Electoral Commission, and it's a very key point people make. So I'll end there. I think there's some useful articles here, and I think it's good that Zim and Narelle have done this article, because I know I spoke to them when they were doing an earlier draft of this, and there's lots of interesting things in this area, the inconsistencies between different states. Congratulations on the journal. It's quite a doorstopper. Congratulations on the sub-editing. I do tables of, I do publications with lots of numbers, and I write databases to ensure that I don't have to type numbers as much as possible, because I know how difficult it is, can actually verify. And I did a publication recently, and everything I typed said automatically was correct. And the only thing I'd done by hand, which was a by-election, had an error. So I can well understand how difficult it is. And as for all those footnotes, well done to actually get it out together. So I think it's my job to launch this. Just say congratulations and welcome to volume 39.1 of the University of New South Wales Law Journal, and congratulations. Thank you.
be rolled to just say some brief thank yous and acknowledgements. If I could start with our main speaker, Antony Green. That was wonderful. You know, I've seen him so many times on the television in elections, and I've thought, this guy knows everything. And it's actually been confirmed tonight, he does. And I kind of wondered what he did between elections, you know, whether they kind of put him away in a box somewhere or something. But of course, now it turns out that he's an expert on New Zealand and American elections as well. So thank you for coming tonight, Antony. That was just fantastic and a really great contribution. Thank you to our hosts, Ross Drinnan and Alan's, for their long-standing support for the journal. The points which Weanne didn't say I should add, which is that Ross is an alumnus of this law school, and he's also been for nearly all the time that I've been dean, a member of my advisory council, and has been a great source of support and help for me. In fact, I feel sometimes that this building is just about being my second home. I've been to so many things down at Allen's, and it's going to be one of those things I'm going to miss after June, I must admit. Congratulations, particularly to the editors of the journal, to Weanne for taking the job of being the boss, which I know is a very challenging one, and to Damien for putting together such a great issue. And look, people have said the line I was going to use tonight already, which is, you know, just how timely the special issue is with the double dissolution coming up. But the journal seems to do this all the time, that they always seem to pick issues which turn out to be really, really, you know, on point. I also thought that the general part of the issue was great. You know, that sort of wide sweep of issues on euthanasia, sentencing, labour law, discrimination, litigation funding, and last but not least, I hired Gabriel Appleby as one of Australia's leading public lawyers. It turns out she's a cycling lawyer. She kept that bit from us. My last point is that to repeat something which I've said at several of these launches, which is the reason that I've been such a strong supporter of the journal is that the people who are involved in the journal have been so consistently amongst the really leading students in the law school, the people who have not just come top of the classes, but the people who've made a wonderful general contribution. And there's a few of them, a few of the journal alumni here tonight who fall very much into that category. Over the longer term, I was looking a few days ago at a list of the editors of the Law Journal going back to the very beginning. And it's really an extraordinary list which really does substantiate my claims about the journal, that the people who've been editors of this journal have gone on to do amazing things in all kinds of different walks of life. And it is an enormous credit to everybody involved in the journal, particularly, and I'll stress finally the point which I'm so proud about, which is, it's been said before, that this is a student-run journal. It's not like a journal where the faculty kind of organises it and tells the students what to do. It's the other way around. They tell us what to do. That was a joke, no. No, they're fiercely independent in the way in which the journal is run. We are there to act as advisors and helpers, but the fact that you are able to produce something which is one of the very top research journals in this country is, I think, a great testament to the quality of our students. So congratulations to everyone who's been involved in the journal, both this time and all the way back through the 10 years that I've been dean. So thanks very much, everyone, and congratulations to everybody involved. Thank you.